Yes. And I'll request Amar to felicitate his lordship with a sapling. Thank you very much for your presence, Justice Chandrachud. As you can see, many people have braved the rain to hear from you this evening. So, ladies and gentlemen, thank you very much once again, and we are very glad that all of you could be here. Today, we have gathered together to celebrate really a discussion that we are having with the 50th Chief Justice of India, Dr. Justice D.Y. Chandrachud. Those of us who work in the disability rights space are very familiar with his both judicial and administrative interventions as a judge of the Supreme Court and later Chief Justice of India. Just to name a few, on the administrative side, he sanctioned the commissioning of the MITI Cafe in the Supreme Court, which enables people with disabilities to kind of be providers of economic value rather than recipients of them. He also set up the Accessibility Committee in the Supreme Court, which I had the opportunity to assist with. Along with that, he also commissioned a handbook on stereotypes against persons with disabilities by the Center for Research and Planning in the Supreme Court. On the judicial side, he delivered a number of landmark judgments on disability rights. For example, in Rajiv Raturi versus Union of India, which was one of the judgments that he delivered on his very last day in office, he held that the government has to frame a set of non-negotiable accessibility norms to ensure that the right to accessibility gets its full play, on the reasoning that you cannot have a ceiling without a floor, so you need to have a minimum baseline of non-negotiable norms. And I believe Mr. Raturi is here or will be here shortly himself in Nipun Malhotra versus Sony Pictures, and Nipun is also here. He delivered a judgment on the dignified portrayal of people with disabilities in the electronic media. In Om Rathore versus DGHS, he dealt with the exclusion of persons with disabilities from pursuing MBBS and commissioned a report by a doctor with a disability, which led to the person's admission in the MBBS course. In the context of the judiciary as well, he took suo motu cognizance of the denial of reservation to persons with blindness and low vision from the MP judiciary. These are just a thumbnail of the various accomplishments and interventions that he made. I also have a personal connection with Dr. Chandrachud. I was his judicial law clerk in the 2020-2021 court year on my return from the UK after pursuing my postgraduate study. And he has been a guide and mentor since. Let me also say a few words while we all are here about Mission Accessibility, the organization under whose aegis this event is being held. Mission Accessibility is an organization that was co-founded by me and Advocate Amar Jain. Both of us are blind, and we wanted to utilize our lived experience and expertise to help advance disability rights in India. And our core contribution is in terms of providing legal aid to persons with disabilities, not as a favor, but as a mandate on a pro bono or low bono basis. So just to share a few figures, just in the last 1 year, we've taken up 49 cases on behalf of persons with disabilities in courts across India, which includes 23 pro bono cases, 10 low bono cases, and about 12 cases on a paid basis, which is a no profit, no loss basis. 13 of these were in the Supreme Court, 16 in the Delhi High Court, and many other high courts such as the High Courts of Bombay, Kerala, and in the Chief and State Commissioners for Persons with Disabilities, as well as the Central Administrative Tribunal. These range from issues around inaccessibility of digital platforms and media platforms for persons with disabilities to transfer-related issues concerning persons with disabilities and denial of reservation benefits. As we look ahead, though, I would also like to place two kind of considerations for our deliberations to follow, which I hope would be helpful. One is sort of making sure that this kind of provisioning for legal aid becomes sustainable, and how do we maintain that. For example, we have a program where we take up 3 pro bono matters on behalf of persons with disabilities every month, pursuant to which we've done the interventions that I told you about. So one is ensuring sustainability of legal aid at scale to persons with disabilities. And the second is, not getting pigeonholed as just disability rights lawyers, which is something that both Amar and I are feel very strongly that we should not just be boxed in or pigeonholed as lawyers who only do disability rights work, which is why, we are also launching our for-profit law firm today, under which we have been doing cases on behalf of persons with disabilities, but in a formal way, which is called Zen Access Law Associates. We'll also be launching that later in the program today. So I hope that we'll be able to deliberate on these issues. Justice Chandrachud has often spoken on disability rights issues in his speeches, but today the format that we'll be following is a little unique, where we get the opportunity to engage in a discussion with him, based on questions that you, i.e. people with disabilities, have submitted that they would like his inputs on. So I again thank him for his presence, and I'd like to now call on Amar in case he would like to share a few words. Thank you. Could someone guide him to the dais?
Is it okay? Yeah, why don't you take mine?
Yes, sure. Good evening, everyone, and warm welcome to Mission Accessibility's discussion with Dr. D.Y. Chandrachud on disability rights and beyond. So we are immensely grateful to you for your continued guidance, your continued support, and your presence today to discuss on an issue which affects a large population. 16% of the world population, which is 1.4 billion, comprises of persons with disabilities. And India does not have latest figures on that, of course, due to no census since 2011 having been conducted, but we all know that the number is huge. When I'll just kind of give you a very brief of how Mission Accessibility was conceptualized, just to tell you the scale of need that this sector has. We were speaking on call, Rahul and I and one of our another friend who's also principal architect behind Mission Accessibility. And we were saying that we always keep reaching out to service providers for accessibility in our individual capacity. Why don't we join hands, right? And do it in a more collective manner. So then we decided to do it formally as a united voice of a couple of us together. And we got a couple of law school volunteers from NLS involved, and later on it expanded to other colleges as well, where we said that we'll do outreach with brands and service providers to make their offerings accessible. We'll also send them social media outreach, email communications, and if somebody just doesn't respond to any constructive collaboration or a dialogue, then of course we'll use our legal rights and remedies that we have in law. That's how it started. It soon got converted into a WhatsApp group where we started with about 10 to 12 people. Today we have about 656 people on our WhatsApp community called Mission Accessibility. After that, initial successes with a few brands which we kind of had to make their ecosystem more accessible, both Rahul and I decided that let's create a system which does not depend on us as two individuals but can sustain on its own, whether tomorrow we are there or not. That's how we conceptualized the idea of forming a not-profit entity called Mission Accessibility as a Section 8 company, and that's how Mission Accessibility was born. Soon we realized that the need was only just not restricted to accessibility. The need was also for competent legal aid, competent legal representation, spreading awareness about legal rights and entitlements within persons with disabilities, and spreading awareness amongst the network of people without disabilities as to what are the rights and entitlements that persons with disabilities are entitled to. That's how the whole strategic intervention in grievance redressal vertical was born. And both Rahul and I started taking up cases on behalf of persons with disabilities. We always wanted to do as professionals more. Both Rahul and I have the aspirations of doing more. So we first started catering to persons without disabilities who wanted legal aid as beneficiaries of the system. We are grateful to Delhi High Court for giving us the opportunity of being impaneled on the panel of Delhi High Court Pro Bono Legal Services Committee, Legal Services Committee Pro Bono panel, wherein Rahul and I provide legal services to beneficiaries on a pro bono basis. Also grateful to, again, Delhi High Court for setting up the Accessibility Committee and Supreme Court of India for taking slew of measures to make sure that persons with disabilities are able to excel in the profession of law. Slowly, we expanded legal aid to both persons with and without disabilities. We also started a helpline called Justice Connect, wherein we provide pro bono legal advice on for 1 hour every week, Thursday between 5:30 to 6:30 p.m. And we just don't restrict ourselves to persons with disabilities. We also cater to persons without disabilities who are in need of legal advice. And this is, the legal advices ranges from property disputes to family law disputes to any civil rights matters that we typically come across in day-to-day life. That's how the journey of Mission Accessibility has been. As Rahul mentioned, we both wanted to also professionally excel beyond disability rights. Hence, we also decided to set up our own law firm, which is led by people with disabilities, but disability is not the limit when it comes to performance, when it comes to professionalism, when it comes to excelling. So Zen Access Law Associates as the law firm has been conceptualized with that motto. And I'll hand it over to Rahul to take this forward from here. Thank you, everyone.
Yes, thank you. Thank you very much, Amar, for setting the context quite wonderfully. Just to, tell the audience, for example, he mentioned about the Justice Connect helpline. Now, we figured that we were getting a lot of queries by persons with disabilities in need of legal aid, and we thought we should streamline it. And just in the last, we started this on 9th January, so about 3 months ago. In the last 3 months, we've answered as many as 94 queries by people with disabilities, looking for legal help. I'll now invite, so we have a small segment before we hear from Justice Chandrachud, where we would just like a couple of, people who are here in the audience whose lives have been positively impacted by his interventions to come and say a couple of words. So first, I'd like to call on Nipun Malhotra, who's here, whose case I mentioned. So if Nipun could come and say a few words, and then we'll hear from Siddharth Sharma. Yes. Not sure in the mic if it's carrying.
Yeah, we'll just, how could you just? Yeah.
Hello everyone. It's really an honor to be sharing the stage with Justice Chandrachud, and thank you Rahul and thank you Amar for really giving me this opportunity. I filed a case in 2024 in the Supreme Court against this movie called Aak Micholi, which Sony Pictures had released. The movie was very derogatory in nature, made fun of a lot of disabilities, and the synopsis really was that if you are a person with a disability and you want to get married, you should really hide your disability if you really want to have a chance. And I thought it really reinforced a lot of negative stereotypes. I'd gone to the Delhi High Court and I'd lost the case there. And that's when we went to the Supreme Court. Justice Chandrachud actually asked for the trailer of the movie to be shown in open court. I think that was a historic moment in itself. And I remember in the chambers there were a lot of lawyers who were snickering, laughing, a lot who were shocked as well. There were all kinds of reactions. And then Justice Chandrachud had asked me this question that, do you think all kinds of disability humor is wrong? And I'd said something which he articulated much better in his judgment later, where he separated between disability humor, which is humor laughing around situations persons with disabilities face, which should be acceptable because that creates awareness around disability, and disabling humor, which is humor that laughs at the disability itself. And for the first time, guidelines were really created for visual media when it comes to portrayal of persons with disabilities. And I think these guidelines are going to be really historic whenever any future content is created around disability, because they give a standard to all content creators on what they should live up to. So thank you, sir, for this intervention. Thank you.
Thank you, Nipun. May I now call on Siddharth?
Use the mic. Left is sir. Just go close to the mic.
Good evening, everyone. So my name is Siddharth. Recently, with the timely and kindly intervention of Justice D.Y. Chandrachud, sir, I have selected in Rajasthan Judicial Services as a judge. So my case evolved regarding... So my case revolved around various discrepancies regarding implementation of reservation for the persons with disability in the judiciary, both at the entrance level as well as the district judiciary level. So there was some misinterpretation of law regarding horizontal reservation and its applicability for the persons with disability. There were numerous judgments of high courts, there were numerous adverse judgments of various high courts as well as the Supreme Court. But Chandrachud sir was presiding the three judges bench, and as soon as he got our case, I was sure that once we got a fair chance to be heard and a patient hearing, there is no way that we fail to convince the court that we have a case and we have a cause. So fortunately, we timely get the chance, and sir gave us the patient hearing, and we able to pursue the court to follow the correct position of law. So now everyone, regardless of their disability, is equally entitled to for the reservation benefits while pursuing their judicial examination ambitions. So thank you so much. Thanks so much, sir.
Thank you very much, Siddharth. With that, may I now invite Dr. Justice D.Y. Chandrachud to share a few opening remarks briefly before we get into the discussion that we're going to have with him.
Thank you very much, both to you, Rahul, and to Amar, for putting this together and for inviting me here this evening. I'm particularly thankful to all of you for spending time to be here. So many very busy people. Justice Pratibha Singh, a very senior judge of the Delhi High Court, has shown her commitment to a social cause by being present here this evening. The Commissioner for Disabilities is here and again reflects on a shared aspiration. We have lawyers who are appearing for these causes, Shadan Farasat is here, who has ably argued matters in my court for this cause. Former judges of the High Court, Justice Pankaj Naqvi, who was a very distinguished colleague in the Allahabad High Court, is here. And so many of you whom I will now not really mention, only because I have to be brief to 3 or 4 minutes. Well, as when I was young, my mother had something to say which has never left me. And she would always tell me that when the heart is full, the tongue is tied. And she obviously didn't refer to it in a disability sense, but in a purely emotional sense. So truly, truly, my heart is full this evening by just listening to the stories of Nipun, of Siddharth. As a judge, you just don't imagine the impact of what's happening through your judgments. Just a few weeks ago, a young lawyer from Mumbai, and I'll mention his name, Rishabh Vidyarthi, called up and said that now that you have retired, and can I come and share some experiences of a case which I argued before you? And I said to myself that there's no bar now that I've ceased to be a judge in meeting a young lawyer who wanted to tell me about a case. And it happened to be a case on disability, as he told me on the telephone. And he said that this young student for whom he appeared and was able to get admission to medical college, a government medical college at that, after a beautiful report was done at the behest of the Supreme Court of India, is now doing amazingly well in the medical college. There are 10 different reasons why you should deny relief or not do something for those who demand reasonable accommodation as a matter of right, not as a matter of concession. But we need one good reason as citizens, as co-travelers on this path of life, to provide them, and for all of us, a footing of equality. I must tell you that I learned so much, and my whole outlook towards the rights of those who suffer from disability changed when I had my first brush with Rahul. Rahul was then a Rhodes Scholar at the University of Oxford, and he wrote to me saying that he wanted to clerk with me. And my instinct was that why on earth would someone give up a Rhodes Scholarship to come and clerk with a judge of the Supreme Court? But he had a condition. Rahul said that he had already worked with Justice Lalit as an intern before he worked with me. He was going to work with me. There would be several adjustments which would have to be made in terms of the digitized files, the OCR-enabled digitized files, the audio capture of the Supreme Court instead of the visual capture, so on and so forth. And these little interactions really, over a course of 1 year, changed my life. I'm delighted to know that this has made a difference on the ground to so many of you who are present here this evening. I'm delighted about mission accessibility. Truly, the word mission accessibility signifies what we expect from society. I must share with you just an experience which I had this afternoon. I have to vacate my official residence as Chief Justice of India on the 30th of April. And like everything that I have done, even the judgments had to be polished until the last minute, corrected and edited until the last minute. I don't have a place to stay beyond the 30th of April. So we've been looking for a place on rent. We have 2 beautiful daughters who are children with special needs. I'll be speaking about them in the course of the dialogue this evening. And we realize that every house that we go to for finding something on rent is just not equipped to have a family with children, or for that matter, with adults who suffer from disability. We just saw a lovely place this afternoon, and every room was in different levels where you have to cross a step. Now, how does a person in a wheelchair navigate this? And the nice landlord said that, well, I'll put up a wooden ramp, not quite realizing that a wooden ramp is not just putting one little connector between level 1 and level 0, but much more. And that was really the thought which went behind Rajiv Raturi. The last judgment, almost the last judgment which I delivered before I laid down office, about the need to redesign public spaces across India, whether it's in terms of transportation, it's in terms of access to housing. Almost every conceptual design in the urban and rural space has to be rethought of in terms of making it disabled friendly. So this is really a part of my own personal experience which brings me here, and hopefully inspired by all of you who have surmounted so much, I'll be able to find a house after the 30th of April. But the fact of the matter is that for too long, our society has kept the disabled under a curtain of ignorance, under a curtain of suppression. Just 3 weeks ago, I got a lovely email from a mother, and she said that she wanted to bring her daughter to come and see me, and they were going to travel from Hyderabad. And I responded by saying that, well, instead of coming from Hyderabad, I'll come and meet you when I visit the city next time. And she had a wonderful story. Her daughter suffers from SMA, spinal muscular atrophy. She cleared the IIT JEE. She was given chemical engineering in IIT Delhi and IIT Mumbai. And they said, what is she going to do with a degree in chemical engineering? She wanted to do engineering and information technology. But for that, she had to move to Kanpur. So her mother gave up her job. Her father continued to be in Gurgaon because somebody had to be sustaining the family. The mother moved with her to IIT Kanpur, where she completed her BTech and now is employed with a large multinational, with Microsoft in Hyderabad. But she too shared with me that though they found a place next to the Microsoft office, the real challenge is to traverse the 400 meters between home and the office, where you have to cross cars, there are no pavements, even for able-bodied people. But then we need to look beyond disability as well, because disability is one paradigm, albeit an important paradigm, of a whole class of citizens. What about the elderly? What about those on crutches? When my father-in-law was in a situation where he was not able to walk on his own, we realized that you had to have crutches and move the furniture in the house around so as to allow him to navigate the space of a small flat in Bangalore. So these are some of our own lived experiences of life, and I thought I'd begin my little presentation this evening by telling you about my own lived experiences. We have had persons with disability with us in class and school, in college, as professionals, but there is change which has been brought about in our society. I don't want to be misconstrued to say that, well, we are still in the dark ages. We are certainly moving from darkness into light. But the reason why we are moving from darkness into light is because of the fact that you have people like Rahul and Amar who have taken upon themselves the mantle of mentoring others from their community, but more important, of acting as role models for the rest of society as well. Because their mission and mission accessibility, in that sense, is a torchbearer for others across society who need to understand that they have to take the first steps, and more than the first steps, to realize the mission and the vision of a transformed society. I think I'll conclude here. I'm not going to bore you with details on the law and reasonable accommodation and the RPWD Act. I'm sure all of you live and breathe the Act much as I have, understanding the nuances from case to case. But as we go along with the questions this evening, I think some better synthesis will emerge. So I'll stop here and then open it up for the questions.
Thank you very much, Chief Justice Chandrachud, for your enlightening and insightful remarks which have really, helped bring into focus the issues that in the disability rights space kind of form the subject matter of a lot of discussion and deliberation in terms of accessibility, non-negotiable norms, valuing the lived experience and so on. So in terms of, the discussion we were hoping to have with you. So what we had done is, in the month of, I believe, February, after Amar and I met you, we had put out a form for people to submit questions that they would like to seek your inputs on. And we got about 35 to 40 questions, out of which we've selected 8 that we'll be requesting you for your inputs on, and of course after that there will be 15 minutes of Q&A with the audience. So let me kind of start off with this question, Chief Justice, that when you were CJI, one of the most important administrative interventions you made was to start the MITI Cafe in the Supreme Court, which, as I mentioned earlier, is predominantly run by people with disabilities. Can you share a little bit in terms of, what motivated you to take this step and what your experience was? Because one of the things we see, whenever I go to the Supreme Court, I make it a practice to go there, and it's always very crowded. So, even without being kind of a disability rights sort of an intervention, it ends up portraying people with disabilities in a very different way.
Well, my interface with MITI Cafe actually began when my wife was invited to a program at Hansraj College by this young proprietor who has set up MITI Cafe. I thought that it is important for a space like the Supreme Court to have MITI Cafe within its precincts in order to convey, of course, here to lawyers, to litigants, to everyone who comes to the Supreme Court every day, about the fact that disability, in that sense, is no barrier to seeking dignified, productive, and useful coexistence in society and at the workplace. We even have in the MITI Cafe a young couple who met during the course of their work in another MITI Cafe, and they got married and have a child. And we therefore wanted to show to society that despite the constraints which any condition of disability imposes, and we'd be really hypocritical not to accept the constraints which arise, notwithstanding that every one of those individuals is capable of leading a dignified existence and of being a service provider to us, the rest of society, and not just as a service recipient from the rest of society. And I think that's very important, because when we regard the role of people who suffer from disability as not just as objects which require an element of special treatment, but as people who bring to our life meaning just like anyone else, I think our assessment, our view on disability itself undergoes a change. That's something which I learned from my own daughters. You don't talk about them being less able than anyone else in the family. You talk about normal stuff that each of us is interested in, that each of us is moved by. And one last thing which I wanted to share with you about the MITI Cafe was this, that when we had the inaugural of the Dr. Ambedkar statue in 2023, in November 2023, on the occasion of Constitution Day, the President of India came to the Supreme Court. And after the Honorable President inaugurated MITI Cafe and we were walking back to my chamber so that she could take the car to the auditorium, I looked at the President and I said, ma'am, we have the MITI Cafe here, which is entirely run by persons with disability. Would you like to just step into the MITI Cafe for a moment? And a little bit to the consternation of the security personnel, she says, of course, she said to me, Zarur jayenge hum. So she turned around and she went into Mitti Cafe and she sat on the tables in the cafe, spoke to everyone else. And the net consequence was that Rashtrapati Bhavan has decided to open Mitti Cafe within the presidential estate. And now this movement has caught up all over the country. You have Mitti Cafes at the airports. And therefore, this is really an indicator of the fact that you have to pitchfork persons with disability into prominent places of responsibility. Mitti Cafe is an illustration. And this has to spread. You have now Professor Sanjay Jain, who is the principal of ILS Law College in Pune, who has again been an enormous source of inspiration for me personally. He's also blind. And now a full professor at the National Law School of India University in Bangalore. And I think it's important that we share these stories, share these pieces of anecdotes, so that people around realize the kind of work which is being done and which persons with disability are capable of doing, if only you don't raise social barriers to them, if only you provide an equal platform for achievement as for anybody else.
So, with that, you briefly mentioned about your two daughters who have a disability. We hope to invite them to our next program for sure. I wanted to ask you, sir, as a father, when you kind of interacted with your daughters in your day-to-day life, when you saw their challenges, when you realized their talent and potential, when you saw their capabilities, how did that overall experience shape your own thought process towards disability rights and the need for justice?
The first aspect which I think I must mention is that even coming to terms with and understanding that our two girls, Priyanka and Mahi, suffer from a disability. They suffer from a genetic disorder called Nemollyan myopathy. They came to us when we were in Allahabad. I was Chief Justice of the Allahabad High Court between 2013 and 2016. October 2013 and May 2016. When they initially came to us, they were virtually just a piece of bones with a little bit of flesh. I do believe the mother had completely neglected them, thinking that it was a lost cause. No one knew what myopathy was about. We took them to the Postgraduate Institute in Lucknow, where a very invasive test is done for testing myopathy, which is to take a sample of the muscle. And it's one of the most, at least at that time, now you have blood tests which replicate that. It's an extraordinarily painful process because there is no anesthesia which is administered while taking that sample of the muscle. And I still remember when we tried to do that in Lucknow, the doctors just couldn't do it. They couldn't get round to taking that sample. The next time it was done was when we came to Delhi in 2016, when it was done in AIIMS. And the one thing which my older daughter said was she was in intense pain when that sample was taken. And in that pain, she constantly kept on saying, I don't want my sister to go through this. I hope they're not taking her into the OT to do this. But that's, how, our brush with so many of the genetic disorders is lack of knowledge, lack of investment in terms of public resources. But answering Amar's question, I think in so many which ways, again, my life and our life, both for Kalpana and me, has been completely changed by what we have learned from our two daughters. They have a vision of humanity and what it is to be humane. They are like each of us. They are like young adolescents with every one of the foibles which we all had when we were young adolescents. They are fierce environmental activists. Both of them invited us to turn to veganism. They are proponents of an ethical lifestyle. And they're both of the view that in everything that we do as humans, we should ensure that every element of planet Earth is treated in a dignified way. When our little Mahi was being counseled by a nutritionist and she was told, why don't you have a couple of eggs every day? She said, it's not that I don't like the taste of eggs. She said, I don't feel good about eating eggs. And her reason was very simple. She said, well, when I look at the eggs on my table, I think of the manner in which we house all the hens who produce these eggs in small cages. And therefore, she was the one who really turned us into becoming vegans. She's amazing with animals. She's amazing with birds. If there's a bird who is distended, a bird who is injured, she's the one first to go to help. She's wonderful with every kind of creature on earth, even if it is a ladybug in the garden, to the monkeys who are never shooed away from a garden in Luton's Delhi. To tell you in a lighter vein, there's a cadre of officers, a cadre of employees called monkey chasers who are found in Luton's Delhi to chase away the monkeys. But our girls said that if you chase away the monkeys, they just go to another home. And why do they land up in our gardens in the first place? Because we as humans have displaced them from their habitat. They come into our habitat because we have displaced them by the travails of development, of unrestrained development in urban spaces. So I find every day that I talk to these girls, and now as someone who doesn't have the responsibilities of being Chief Justice of India, I have so much more time to listen to them, more than talk to them. I think listening is as important or more important than speaking. I learn so many of the profound truths of life just by observing them and listening to them. So I think what that really teaches you is if you have a little patience, if you have a little time, and if you care to take a moment away from your own busy lives and schedules, you realize a great deal of what should enrich you in your contact with the disabled, as I have with my own daughters. Thank you.
Thank you.
So now, the first segment was really on your personal journey and your interventions. In this segment, we'll be requesting you for your inputs on a few questions that people have asked about, disability rights law and policy in the country. The first of these questions is from Anand KN, who says that because of the heavy workload that all our judges are under, we find that sometimes cases of people with disabilities take a substantial amount of time to get resolved. Now, one practice which has been adopted in some high courts, for example in Karnataka and Delhi, is to prioritize the hearing of cases of persons with disabilities so as to ensure that they get the requisite time and attention. Is this something that you think should be adopted in other high courts or in the Supreme Court? And are there any other interventions that you think can be thought of to ensure that people with disabilities are provided speedy justice?
Absolutely, Rahul. I think creating a special bench is one answer. For instance, you have the green benches, you have senior citizens benches. At the same time, there are two views about it. Having one bench for dealing with cases on disability may provide for expeditious justice. But honestly, you must also have a bench with the requisite empathy and understanding about the rights of the disabled. And therefore, speaking for myself, I think it's equally important to diversify on disability issues to different benches, because hearing a case on disability is not like hearing a case on the Insolvency and Bankruptcy Code, where you require somebody with that very highly specialized domain knowledge to deal with a case on financial regulation, or say a case on electricity law, where you again require somebody who has a very innate understanding of the niceties of electricity law. Disability law is very different. Disability law cuts across the whole of the societal gamut. And what you really require are people with vision, people with a heart, and people who understand the fundamental basis of laws such as the RPWD Act. But what happens is that once these cases gain traction, and I must compliment you and everyone who's working in this space for bringing these cases to focus, like we had Nipun's case, the Ank Micholi case. We had the case of the medical student to whom medical admission was denied because he had a disability in excess of 80%, 87%, I think, if I'm not mistaken, 88%. So when these cases gain traction and they are heard, there is a quantum shift in the approach of judges. You must realize that this is the same Supreme Court which, say, 5 or 7 years back, had said that someone who is blind cannot enter judicial service. Because the argument was that when you look at the evidence of a witness, you must assess the demeanor of a witness. And if you don't have eyesight, how can you assess the demeanor of the witness? So this was the very Supreme Court which had said that. Now, there is a flip side as well, which is rarely today does the judge who record the evidence actually decide the trial, because there's just too much of work going on. So that this whole theory that you must be able to see the demeanor of the witness is more theory than practical reality. And judges ultimately learn to read between the lines. And that's as important as just physically with your own eyes observing a witness. But this was the same Supreme Court which then reversed its earlier decision and said, as Siddharth said, that, well, in the Rajasthan Judicial Service case, that people with visual disability should not be barred from seeking, engagement in the judicial service. So what's happening, as you see over a period of time, and this is an unmistakable movement which is taking place in the Supreme Court, you have now case after case. These are not isolated instances where justice has been done to people suffering from different kinds of disability. But now this is a movement which you see is taking place in the Supreme Court. You had a judgment by my very distinguished colleague, Justice Vishwanathan, again, which upheld the rights of a disabled individual to seek medical admission. So what began as an isolated instance is now becoming a movement, I would say. And by becoming this movement now, we are establishing a body of legal principle which is accepting of the fact that persons with disability are entitled as a matter of law, as a matter of constitutional right, not as a matter of charity or concession, to realize their rights on an equal platform. So I think, Rahul, to answer your question, it's important to bring these cases to the fore, to tell the court that, well, there is some urgency about it. If you don't look at my admission case when I'm appearing for the IIT, JEE, say next week, now I would lose this opportunity for the whole year. So it's important to highlight these cases, bring them to the attention of the court. And I dare say that there is now a quantum change that is taking place in the thought process in our judicial institutions. And this is now spreading to the high courts as well, as I gathered from what you shared with us just a short while ago.
Thank you very much. The next question is by our colleague at Mission Accessibility, Sarah, who works with us as a litigation associate. Sarah, go ahead.
Good evening, sir. Sir, the recent economic survey has highlighted mental health as a growing economic concern and has also highlighted the need for early intervention. We've seen an unprecedented hike in the rate of student suicides. As a lawyer, how can I use the judicial mechanism to ensure greater accountability, proper resource allocation, and implementation of evidence-based interventions?
You know, the Mental Health Act, Sarah, is one of the most forward-looking pieces of legislation that India has enacted. Now the real challenge is how do we ensure that the Mental Health Act is implemented on the ground. For instance, a very salutary thing that was done by the Mental Health Act was to decriminalize an attempt to commit suicide. The 1860 Act, which we had, treated any attempt to commit suicide as an offense against the penal law. the whole emphasis is now shifted into looking at people who are in that position as really people who are in need of rehabilitation and care, as opposed to penal sanction. Coming to your question, I think it's now important to accept the fact that mental health is under serious stress in urban environments. The legal profession is perhaps the chief amongst them, because lawyers typically have extraordinarily stressful lifestyles. Lawyers working in law firms have to put in crazy hours of work. It's almost understood that if you go to a law firm, that you will live a life where there'll be no days off, that you are not entitled to seek a reasonable time schedule for work, so on and so forth. And obviously it's going to take a toll of mental health. And there's been very little focus in our society on the need for propagating issues pertaining to mental health. And by saying that we should have 70-hour work, 70-hour working weeks, we're not doing any good to the system, are we? Because you're only adding to the burden of a labor surplus economy. For every one person who falls out of the workforce, the employers are conscious of the fact that there is another one who will come and easily fill up that role. For every lawyer who leaves a workplace, you will have another young lawyer who is ready and eager to take up that job for whatever you will pay him or her. So I think it's important that a concerted effort can be made, and lawyers have a very vital role in that, by using their specialization and their experience and the good offices of the institution of the court to bring together diverse cross-sections of the community and society and government into one level platform, to have a deliberation on what can be done. Very often the court is utilized now, as you see, not as an institution for resolving conflicts, but as a focal point for creating dialogue. For instance, we had a case, for instance, where the Supreme Court has been monitoring the setting up of halfway homes for people who have been rehabilitated from mental illness. Very often, persons who suffer from mental illness are not accepted by their families after they are through the process of recuperation. Now, what do you do with those people? And it was found in the course of deliberations in the court that most of the mental health, or so many of these mental health institutions, which are government-run mental health institutions, keep these people back in the mental health institution, even though they have no more need, any need to continue to be in the mental health institution, because they have no place to go to. There's absolutely no place to go to. I remember as a young judge sitting in a division bench of the Bombay High Court, where there was someone who had been cured of a mental illness, and that matter would come to us in chambers. We issued notice to the family, and the family refused to accept them. And that person was lodged at the mental health home, if I'm not mistaken, in Thane in those days. So these are some of the realities. Now, how do you therefore ensure this can't be dealt with at an individual level? There has to be, first and foremost, an adequate budgetary allocation. That's something which we did by utilizing the good offices of the court for setting up halfway homes across India. So we used the modality of the court and the institutional role of the court to put together a multi-layered and multi-sectoral initiative for, say, treating a problem like the rehabilitations of people who have been cured of mental illness. A dashboard was prepared by the ministry and the government of India. That dashboard gives real-time information on which are the halfway homes which are available. What is the availability of accommodation in those mental health homes? Where are they situated? How are they monitored? So I think I just gave this example to highlight that a young lawyer can really, in that sense, by bringing these issues to the court, allow the court to be used as a sort of a platform to bring together diverse segments of the society. For instance, the states and the center. We're not only talking of the central government in these cases, you're also talking of the states, because we're a federal country. And the implementation of central policy is carried out by the states. Now, very often the central government is handicapped by the fact that they're also looking to the states to persuade them to come on board. And every state is not necessarily on the same wavelength, but utilizing the court as a sort of a point which is not adversarial, but brings together diverse viewpoints, diverse cross-sections, diverse institutions in the country, can perhaps be one way. But having said that, let me end my answer to you by saying that the court is just one avenue for bringing about change. Let's not belittle the role of civil society. The court has to step in perhaps because somebody has to take upon this responsibility. But I'm not sure whether the courts are equipped to deal with each one of these social issues. The courts don't shirk away from handling those problems, but I know the limitations of the courts as well.
Right. Amar, the fifth question, should I ask?
Sure.
Yes,
So
we will.
we'll come to that section as well.
Yes.
For now, we'll continue with the questions that we have. Go ahead, Rahul.
So this question, Chief Justice Chandrachud, comes from the Manipur State Commissioner for Persons with Disabilities, who has a question on the RPWD Act itself and the powers of the disability commissioners. So as you are aware, under section 76 and 81 of the RPWD Act, the framework that the law creates is that recommendations made by the chief and state disability commissioners are binding unless the respondent institution, and it talks about government institutions here, it's silent on private institutions, are able to give a reason within 3 months to the commission and to the aggrieved person as to why they are not complying with the given recommendation. Now, in recent times, there has been a lot of discussion within the disability rights community as to whether the disability commissions need to be given more teeth. And especially this arises in the context that obstructionist institutions may cite some or the other justification in terms of cost, complexity, etc., to shirk away from having to comply with disability rights, because sometimes it does require a modification in the way they do things. So in this context, he's asking whether you feel that there is a need to have a relook at the powers of the commissions and to perhaps give them the power to issue binding orders and more coercive powers, and whether this requires a legislative reform.
It will require legislative reform. And I think it's important that, now that a fair bit of time has elapsed since the RPWD Act the second version was enacted, to re-look at the powers of the commissioners for disabilities, to give them a more participative role and a more binding character, to allow for their directions to be implemented. Because if we have to truly achieve the purpose and the object of the statute, which is salutary, the commissioners must have greater teeth and to enforce their directions. The second area, of course, where I think the commissioners must have extensive powers are in regard to the private sector as well. Because employment now is gradually shifting out of the public sector as the private sector enters more and more fields of economic activity as opposed to the role of the government in the past. So I believe that it's important that we re-look at the Act from both perspectives, strengthening the role of the commissioners and also analyzing to what extent, and this can be done in a graded way, that the private sector should also be made accountable to the enforcement of the RPWD Act.
Right. Amar?
So that actually brings me to private sector, because as you also pointed out in your last answer, that private sector accountability from the Act is missing. And we see very often that when we take up cases against private sector, they'll cite some or the other justification for not complying with the directions issued by the chief commissioner or the state commissioner, as the case may be. And also it has been kind of argued, and this is a question coming from Diksha Malik and Ashutosh Yadav, that private sector does not, the Act does not give enough teeth to enforce obligations on accessibility and reasonable accommodation against private sector. What do you think could be the way forward to ensure that private sector is also able to comply with the provisions of the law in a non-discriminatory manner? And how could we kind of use the existing law that we have, including allocation of business rules, etc., for ministries, to make sure that private sector also ensures compliance with RPWD Act in its totality?
I think the way forward, really, if we have to have a statute which will have teeth, is to provide for sanctions. Now, I'm not personally speaking a proponent of criminal sanctions, because you look at the Shops and Establishments Act, you see all the labor legislation which had criminal sanctions. It only adds to the burden of courts and does not really produce any outcomes. A criminal complaint would be filed, it would lie pending in the court for the next 10 years, and courts are overburdened, and this will just add to the burden of the courts. I'm not saying that in a negative sense, but in a positive sense, that if we want early outcomes, I would rather prefer a non-criminal monetary sanctions approach in terms of which the commissioners with disabilities are entrusted with the power or the exercise of the power to impose monetary sanctions on non-compliant establishments. The other way may be, of course, to lay down time schedules for compliance and then monitor compliance with those time schedules. The third would be really to get some element of voluntary compliance. I think the best way perhaps would be to look at the largest employers in the private sector. Who are the largest employers today? Have some sort of rulemaking coupled with the imposition of monetary sanctions on the largest employability in the private sector. Instead of targeting that individual trader who has a small shop, target the large organized sector in the private sector, and then impose graded time schedules for compliance on them in terms of which are the occupations in which you must ensure compliance with the Act, and then gradually spread the ambit of the Act, say over the next 5 years or the next 10 years. Because if we spread ourselves too thin all at once, I'm not sure whether we have the infrastructure, even with the Commission of Disabilities, to properly enforce the provisions of the Act. So, insofar as the private sector is concerned, a large part of it is also about creating awareness, creating motivation, creating some sort of rewards for the private sector to comply. What kind of rewards there should be? Should they be in the nature of financial reimbursement? Should it be financial rewards? Should they be in terms of tax benefits? That's again a point which really is a policy issue which would require multi-sectoral stakeholder consultation. But you can even envision, say, tax benefits for the kind of compliance with private corporates would be, persuaded to put into place.
Right. My next question, sir, is on ensuring that initiatives in the disability rights get the requisite support that they need to realize their full potential. So we find that a lot of causes in the disability rights space, do not realize their potential for want of adequate resources and support in terms of CSR funding or support from high net worth individuals, and especially in our context of legal advocacy, given the strong linkage between disability and poverty, we find that there is a lot more demand for legal advocacy, high quality legal advocacy than people are able to provide, at least organizations like ours. So there is definitely a need for philanthropic, a strong foundation of philanthropic support to be able to sustain these kinds of initiatives at scale. So what would kind of your message be to people in those positions of influence who may be listening to you in terms of supporting disability rights causes in a generous manner?
I think there has to be a greater collaboration between the academia on the one hand and the corporate sector on the other hand. We found how, for instance, the work which was done by Nalsar led to the judgment in Rajiv Raturi, the Center for Disability Studies. Now, that is an example of how a scientific and concerted engagement by an academic institution brings, public focus on the nature of the issue which is to be resolved. But then going beyond that and bringing about a greater collaboration between, say, CSR initiatives in the corporate sector is all a matter of legal advocacy and social advocacy. And I was just on a slightly different plane when I was getting ready for this evening. I noticed that on one of our popular social media websites, there is an article which says that the president of the Supreme Court Bar has put together a corpus of about 45 crores for the benefit of providing insurance for lawyers. And I said, if that can be done for providing for insurance for lawyers, which is really good in itself, because I know how lawyers suffered during the course of the COVID-19 pandemic, because they have no social security, period. This can be done in the disability rights segment as well. By creating, say, you have the IDEA initiative, which, Professor Shamnath Bashir was so successful in setting up. Now, what initiatives like IDEA or SEED, which is another initiative which deals with the rights of marginalized students, has done, is to bring to focus, the needs for putting and pitchforking these young, talented individuals from this sector into different occupations. We tend to talk only about the law because we are all lawyers. But law, we must understand, is only a small part of the overall slice. How do we ensure that more people enter into engineering colleges, medical colleges? We're already ensuring that more and more of them are entering into medical colleges. More of them enter into the academia. Why is it that you have only one professor like Professor Sanjay Jain who's gained that national prominence? You have others, of course, who are younger, and I'm sure they do better as well as time goes on. So I think there's a great deal to be done in terms of social advocacy. What's happening today is that great social advocacy is being done by individuals, by parents with children with disability, who have sort of set up organizations to deal with that particular genre of disability. But we lack an overall national framework of private organizations who can come together and then take up the whole issue of disability on a more concerted platform. And I would therefore leave it to people like both of you and everybody else who would like to be associated with the cause to put together something which provides for national advocacy, which brings together parliamentarians, legislators, the commissioners of disability in the states who are doing such amazing work, the commissioners of disability at the central level who are doing such amazing work. Individually, everybody is doing a great job. How do you then make sure that, the efforts are in that sense brought together in a more cohesive platform to give it a national focus?
So on this, I would like to ask a follow-up question. It's not part of the agenda. Often advocacy is seen as a negative tool to generate conflict, etc., right? Or seen in an adversarial manner, which is why you see that CSR money, for example, does not go to any advocacy-led initiative. Mostly it's either the foundations or the philanthropists who want to contribute to such initiatives. What would be your thoughts and guidance to tackle that challenge?
Well, part of it is ideological. And I don't want to go into the reasons for the ideological approach on the advocacy groups. But even assuming that what you say is right, yes, and there are foundations, why don't those foundations take up the issue of advocacy in and of themselves? And why shouldn't there be this broad collaboration between people in the advocacy group, in the advocacy sector? Right. Now, say people like Rahul and you, or anybody among the lawyers, Shadan is here. These are people who, you're not just in the advocacy group. You're not just doing disability work. All of you are doing work which is not confined to disability. And this was a point which I made when I was having a conversation with both Rahul and Shadan a few months ago, that much as it is important for you to be doing work of mentorship for the disabled, equally, you now have to also go beyond just the framework of disability for the rest of society to understand that people like you can be parliamentarians, they can be judges, they would be doctors. They are capable of leading productive lives as central elements in society like anyone else. So I think, insofar as this issue of advocacy is concerned, again, this is a case where there is a great deal of need for collaboration between different segments the foundations, the advocacy groups. And so long as, this really does not become ideological in its focus and is confined to the nature of the problem, I think we have cause for hope.
So my next question really sets the vision for Zen Access Law Associates and many like Zen Access Law Associates, individuals also who want to thrive in the profession. For any lawyer, two things are important, and it's equally true for persons with disabilities or lawyers with disabilities. One is economic security or the ability to be remunerated well through your work. And second is not to be pigeonholed as just the disability rights lawyer. We both have, Rahul and I have had our own careers before we started Mission Accessibility. I worked with Trilegal and Sri Ramarchand Mangaldas and then a multinational company in contract management. Rahul worked with IRA Law and Trilegal and then moved on to do his master's. Despite doing well professionally, often people with disabilities who are lawyers are pigeonholed as lawyers with disabilities. And somewhere initially, for the clients also, it's always a feeling that lawyers with disabilities are less effective compared to the other their counterparts. What would be your vision and what would be your thought as to how we can kind of change this narrative and how can we make legal professionals with disabilities visible beyond disability rights and in other branches of law?
First and foremost, presence itself.
Right, sir.
I found that, when a lawyer who suffers from disability is present in court and argues in court, that itself is, in that sense, an exemplar for judges, an exemplar for lawyers, an exemplar for the audience who watches them. Because the court is as much a platform for others to see performance as much as for judges to assess the merits of an argument. So the first and foremost point of emphasis is to ensure greater presence. That can be done by persuading, say, regular providers of work like the government, which is the largest litigant in our court system,
Right.
to provide for a concerted program for engaging lawyers with disabilities in their panels. I'm not sure that has happened so far. I was very happy to know that the Delhi High Court has, for instance, requested you to do pro bono work. But this should not just be confined to pro bono work. Why should there be a perception that, a lawyer who suffers from disability would be great as a pro bono lawyer? Of course he would do she would do pro bono work. But you must also provide them with work which is the high value work as well. And I think the government would be a very important starting point for providing for panel appointments across India, at the district court level, at the high court level, and at the Supreme Court level. And perhaps a joint conference between the Chief Justice of the High Courts, the Chief Secretaries, and the Law Secretaries with the good offices of the Commissioners with Disability can perhaps be utilized to put into place some SOP or a white paper for engagement of lawyers. Second, I think it's equally important for the engagement of these lawyers to be able to use technology. In fact, for me, technology was a great enabler. One thing which technology did was to reduce the emphasis on paper.
Absolutely.
And the emphasis on paper was not just all about, reducing the carbon footprint, but the reduction of the emphasis on paper gave a more level playing field to everyone, whether it was women who found it unproductive to come to court and spend the whole day waiting for a case in court, whether it is for a lawyer with disability who is able to read a digitized file in a far more efficient manner than, running through a Braille paper book. So I think greater use of technology is something which we need to emphasize all across India, not just in the legal area, but across the board, whether it's in medicine or whether it's in accountancy, so as to ensure that lawyers, professionals with disability have a greater footprint in wider society.
In fact, sir, this brings me to a point which is worth highlighting, and it's my personal experience. Delhi High Court had amended its, or had come up with its e-true copy rules, and where they had said that for any lawyer with a disability, if they need access to any judicial record, it will be provided in soft copy, in e-true copy format, and it will be OCR enabled. I had a civil suit of 2009, and the suit was very voluminous. And initially, I remember when these rules were not in place, I got the files, it were all physical, and it was extremely difficult for me to scan an OCR and read them because the papers were not of good quality, the print was not of good quality, etc. But the minute I got through the e-true copy rules, the soft copy, the entire matter became much more manageable, and I kind of could deal with the matter in a hands-on way. So it's truly true that technology really enables if you design keeping needs of everyone in mind. So thank you for that, sir.
Okay, so now we'll take a few questions from the audience. I know Mr. Raturi wanted to ask a question, so maybe we can start with him and then a couple of other questions.
And just a request, please keep your questions very brief.
Well, I really don't have a question, but thank you. It's a privilege to be here today, sir, in front of you. And on behalf of the sector, I would like to say a very, very big thank you for your judgment in my matter. It's truly path-breaking. It's given us a lot of hope. It's given us a lot of hope, encouragement, and in particular, your observations of framing the right to accessibility as a constitutional mandate and linking it to Articles 14, 19, and 21 is amazing. I think we have a lot of teeth now to go ahead and battle in the courts. I must also confess that we really strategized to have the case placed before you.
Possibly shouldn't.
I mean,
Can we
we've
move
been
on?
Can we move on to the next, please?
we've been witness to your judgments ever since your stint in the Bombay High Court, whether it was the Suburban Railway Accessibility PIL, the issue of scribes for blind people in Bombay, and possibly, I think, also the issue of ballot papers for blind people in the 2004 elections. I think so.
Yes.
So we've kept track of your disability sensitized judgments, and we strategized to have the petition before you because we knew that if it didn't happen, we would still be battling it out in the courts for the next 19 years. It's taken us 19 years to reach where we are. Thank you so much.
Thank you very much for, Mr. Raturi, one thing about judging which I must tell you is, judges tend to have a very short memory, and which is for the good or the bad. So you forget a lot of the work which you have done yourself, and just in this brief presentation, you reminded me of work of which I had also forgotten.
No, we kept track of your
Because
judgments,
I
sir.
think, when you write as a judge, you leave it for everyone else. You never
you.
retain it in your mind or in your
Thank
heart.
you for the support
thank
that you've given to our sector over these years. That's amazing, and I think it's part of our disability rights movement now. Thank you.
Thank you. Thank you so much.
Any other questions?
Yeah, I have a question. I too have a question.
Can somebody, Taha or Sara, can you select, 2 or 3 questioners and then take the mic to them?
I am Dr. M.P. Yadav, Professor, Delhi University. I am immensely delighted to hear, to interact with Dr. Justice Chandrachud, a messenger of God on the earth. I perceive him less as a judge, as former CJI, but more as a guide, a guardian, a philosopher, a socialist of humanity, a messenger of God on earth. I'm interacting. I'm immensely delighted. I'm coming to my question quickly. I heard him online. I read his judgments online on computer, and still I was not satisfied.
I got them brailled, and my dear friends, scholars, we are sitting with him. My eyes are welling up. When I read his judgment, I read those judgments biblically, scripturally. I touched every word in braille dots. Sir, kindly, today at least, kindly interact with me or with us, let me correct myself, more as a guide, a guardian, a philosopher, a socialist, not as a judge, not as CJI. Sir, you have authored that judgment.
Ask your question.
Sir, can you
please, please.
Because there are many others who are also keen.
I know you will not allow me to ask, to interrupt the
please,
way I want.
Sir, can you please quickly come to
I'm coming, please. नहीं ऑर्गेनाइज कराते फिर तो घर पे ही बात कर लेते. हमसे नहीं बात करने देना तो हमारी फोटो खींचने के बुलाया है. Let me talk to him. He is a God to me. I am interacting with my God. Today I have got opportunity. I am highly obliged to you for giving me this opportunity. So you have authored that judgment, Ravindra Kumar Dhariwal versus Union of India and others. In that, you have thoroughly explained rights and duties and rights of persons with disabilities. You have cited many legal philosophers there where you say about rights and duties. When you explain rights and duties, you say in that judgment, there were disabled
please,
people have rights,
Thank you very much, Doctor.
they have, others have duties, but
Next
they
question.
fire out the students from the
Mr.
educational
Ambassador wanted
institution,
to ask a
they
question.
fire out the
Good.
employees. So how to remove those barriers?
Thank you very much.
Sir, we got your
Dr.
question. Thank you.
Thank you very much. Mr. Ambassador had a...
I'll just answer Mr. Yadav's last part. You know, you're really dealing with an issue of victimization. That's what I understood your last sentence to mean, that what do you do when an employee is victimized, when a student is victimized? You know, if a student is victimized, that's bad enough. If an employee is victimized, it's bad enough. If he is or she is victimized on the grounds of disability, it's a very serious matter. And I think that's where the need for legal advocacy and the kind of legal aid platform which Mission Accessibility has now created to ensure that people who are subjected to victimization, otherwise most people don't know what to do when you're victimized. Where do you go? You're up against a large institution. And therefore, I think the prominence which is now to be given to these kind of platforms would ensure that, you know, people who would otherwise not have access to justice would have some access to justice. That's, I think, something which we as a society have to support.
Thank you.
Thank you, Rahulji. I am Praveen Prakash Ambas, Deputy Chief Commissioner for Persons with Disabilities, Government of India. Sir, I had very little, a question, small question from you, sir. The RPWD Act 2016 cast most of its obligations on the appropriate government or the central government or the state government. It doesn't use the word state as defined in Article 12. So all the three organs do not fall under the ambit of the Act in a very clear manner. And the obligation of monitoring implementation of the Act is with the Chief Commissioner and the State Commissioner in the center and the state. Sometimes we do get a situation where the accessibility or other issues which are being raised in relation to judiciary or the parliament or the state legislature. So how to tackle those issues and whether it is right time for the other two organs also to have institutions like other than CCPD and state commissioner, we also have nodal officers, grievance redressal officers, district officers. Such institutions are also there in the RPWD Act, but they are not, in action when the matter comes to these two organs, legislature and the judiciary. And the second is, sir, that many times we are receiving replies from the constitutional bodies such as UPSCs and other to say that you are merely a statutory authority, you cannot question our functioning, we are constitutional authorities. So how to address these two issues? Thank you very much, sir.
On the first limb of your question, I think there is, in that sense, a gap in the statute, because the statute essentially relates to, you know, the not the state, as you rightly said. The state includes a much broader array of people. The state includes not just the executive, the legislature, and the judiciary, but includes anybody who is amenable to the jurisdiction of the court under Article 12 of the Constitution, anybody who is a state under Article 12 of the Constitution. It would include public sector corporations, local self-governing bodies, other statutory bodies who are not typically the executive or the legislature. Therefore, I think it's important that at least as a first step, the obligation to comply with the provisions of the Act must also be cast on bodies apart from just the government at the center and the states. We have to extend that obligation to other entities, including the judiciary, of which I was a part, and of course the legislature. And this is not adversarial. This is to ensure that, when, for instance, you say that the obligation to comply with the Act will be entrusted to the legislature in turn would ensure that through the MLAs, the message of the Act percolates to the local self-governing institutions as well, to the Gram Panchayats, to the Jilla Panchayats, to the intermediate, bodies which have been created under the Constitution. So that's the first part of your question. But that there is this need now to broad base the application of the Act far beyond just the government at the center and the states. On the second part of your question, I'm very clear that you may be faced with a constitutional institution, but you're not subordinate to a constitutional institution in your entitlement to enforce the provisions of the Act. On the other hand, and to the contrary, every constitutional institution is also bound by the provisions of the Act, at least in spirit, if not letter. And no constitutional institution can be heard to say that, well, we are not going to listen to you because you're only statutory and we are constitutional. Can the Supreme Court say, for instance, that, look, we are not going to comply with the provisions of the RPWD Act because we are a constitutional institution? Obviously, no. And it's in that spirit that, I set up the Accessibility Committee and the accessibility audit of the premises of the Supreme Court. And when we conducted the accessibility audit, we involved, wider society. We involved the commissioners for disabilities, domain experts, civil society experts, who all gave us wonderful advice on how best we should enforce the provisions of the RPWD Act and the work of the Supreme Court, both in the physical space as well as in the virtual space. So on the latter part of your question, I'm very clear that no constitutional institution can be heard to say that a specialized statute which has been enacted by Parliament to protect the rights of the disabled is somehow subservient to constitutional institutions. In fact, constitutional institutions must also, in letter and spirit, obey the provisions of the Act.
Shall we take one or two more questions?
Yeah, one or two more, and then we'll wrap up.
Two final questions we can take.
Thank you. My name is Tina. I'm hard of hearing. I'll just give you my brief experience that something like if I go to an airport and go to special needs, special assistant desk, they said you have to be in a wheelchair. Or I go somewhere else and I say I'm deaf, they say, okay, here's a sign language interpreter. So the path of taking awareness and raising awareness will take time. I'm thinking that, like the rest of the world, India needs to step up on prioritizing protection of accessibility and advocacy and accommodation by legislation. I think that's the only way it will work, while the private sector and people like us who are working in the field take time to build awareness. We need to prioritize this. The question is this: what steps can the judiciary and the law take to ensure that accessibility and accommodation is a given, it's a default, rather than us having to ask for it every time? So what is the thing, what is the priority that you can, what is the first step that you can take to ensure that that happens?
Right. I just said a short while ago that the Supreme Court conducted an accessibility audit of its premises. I think from there, we can take it to the next level by saying that an accessibility audit should be a mandate in every public space, whether it's a public hospital, whether it's an airport, it's a railway station. So there should be an obligation which must be cast upon every occupier of a public space to ensure the presence, for instance, now for someone who is deaf. Every airport must have an interpreter who would be available at the airport and who could be accessed, perhaps by having a kiosk at the entry point of the airport, or just accessing that service online a day in advance by saying that, well, I'm going to access the airport tomorrow, I'm flying from Delhi to Bagdogra, I would need the benefit of a sign language interpreter for helping me to navigate the space. Because I think this individualization of treatment is critical. Very often what happens, in a society like ours, which has such a large population, there's a tendency to mainstream. We mainstream children in schools, we mainstream patients, we mainstream lawyers, we mainstream everything in our society. Individual treatment is something which is crucial. And in fact, on the sign language issue, that's what I learned from, Sarah Soni's case when she came to the Supreme Court, asking for a sign language interpreter to be provided to her. And I think, accessing the court, perhaps accessing the court for issuing wider directions would be a first step. So different establishments of a public nature, at least, should be held down to providing accessibility within their premises.
I just have one, thank you very much. I just have one thing to add to that.
If we could, sorry ma'am, I think we are running out of
5
time.
seconds.
Maybe one other person.
I have a case in the court as well, in Supreme Court, in fact, for accommodation and accessibility. Sign language interpreter is not an issue. I have problem asking for caption, but that's what I need for my accessibility. So my point is that whoever asks for accommodation in the way we want, if that can be provided, is my point.
Yeah, I think, a national SOP for public spaces is what we can really think of. If we put together this national SOP for people with different kinds of disabilities, so that it shouldn't be left on an anecdotal basis, when a report appears in the newspaper, to suddenly, awaken the conscience of the community. We must prepare that now in advance. Of course, it's going to be difficult. It's not going to be achieved overnight. But preparing the groundwork by laying down norms is the first step to achieving it in the near future.
So I have the unenviable task of coming between the audience and Justice Chandrachud.
So just one question. Roshan here, he's been waiting.
Maybe one last question and then
please.
we can move on because we're running out of time.
He's just signing here, Roshan. Yes. So thank you so much for this opportunity. My name is Roshan. I'm the General Secretary of All India Federation of Deaf. And we all are aware of the numerous challenges that deaf people face, accessibility being, the most. IIT Allahabad, recently there was a case of a deaf person dying by suicide. And it's not just the only one, it's because of the constant barriers we face, because of lack of accessibility and the constant mental turmoil that we go through. And because of lack of accessibility through interpreters, on his birthday, he committed suicide, right? And while he was able to compete and get admission, because the access was not provided, this scenario has happened. And this is probably one case that has been highlighted, but there are so many deaf people who are situated in different parts of the country, and they're suffering right now because they don't have access, because they face barriers on a daily basis. The RPWD Act is there, but our problems have not been solved. The mental health issue is not the problem here, the accessibility becomes the. So his name is Rahul, and I know we have Rahul here as well, and Rahul and Amar, you're having these every Thursday, 5:30 to 6:30, you're providing this free legal aid. And my question is that can deaf people also seek this through interpreters?
Well, of course, why not? I'm sure, Rahul, you'll be able to expand your footprint to providing this access as well. And just talking to you, I thought, why don't we think of something innovative, like teaching sign language interpretation in schools? Children are the most potent source where you can tap it. Why can't we teach sign language interpretation, at least the fundamentals or the basics? You don't have to have something at a very, where you can translate the argument in a constitutional case. But can we not tap young children and teach them the basics of sign language interpretation in our schools, because children pick up things so fast. And it will just send a huge message across society of being an inclusive society sensitive to the needs of people who are in need of sign language interpretation. We need to have innovative solutions like that, and these would not be hugely expensive solutions. They would be cost-effective solutions. And therefore, I think we need to fashion some new ideas and new thoughts of this nature. Tapping young children for education in schools on sign language interpretation may be something which we haven't thought of as a society, which we should really implement.
Thank you. So, I am hopeful that this will be the first of many conversations with Chief Justice Chandrachud, and maybe we can have him again sometime, and because there are a lot of questions that people want to ask him, and it's a rare opportunity for many. So I do understand the sentiment, but I have to at some point draw the curtains on the conversation. So I'll now, for the final segment of this evening's programming, hand it over to Amar for doing really two things. One is, launching Zen Access Law Associates, which I had mentioned, is, our effort to kind of be the MITI cafe of the legal profession, right? To say that, lawyers with disabilities don't just do disability rights law work. They're also capable of doing paid work in other areas of law, disability included, to say that we are disability-led, but not disable-led, but not disability-limited. So I'll hand it over to Amar for that, and also then
So, as throughout the conversation, we have kind of highlighted the point that lawyers with disabilities should be seen beyond disability rights law and in the other branches of law. And both Rahul and I share the professional aspiration of being mainstream legal service provider and professional while continuing to work on disability rights issue through the advocacy and other skill sets that we bring. With that intent in mind, and also to kind of show a proof of concept to the mainstream legal service providers, how lawyers with disabilities can be included in the legal system if we have accessibility and reasonable accommodations. With that approach in mind, we are today launching our for-profit law firm called Zen Access Law Associates. It's a law firm which will currently start with corporate law, which will include contract law as well. And corporate, I, for instance, come with banking and finance and capital markets experience. So corporate law is one of our forte, wherein we'll provide advisory, we'll provide transactional support, we'll provide interface to work with regulatory authorities to obtain consents, approvals, no objections, etc., no objection certificates, etc., and anything and everything that is to do with corporate law. We'll also provide our expertise through Rahul in the area of intellectual property rights, which is all areas of intellectual property rights, right from trademark to copyrights to patents and to so on. We'll also provide core litigation services, wherein for any violation of your legal rights, you can come to us and we'll help you litigate and make sure that the cases is handled with absolute professionalism. While the law firm is led by lawyers with disabilities, of course, it is open for everyone, for both lawyers, for people with disabilities and without disabilities. And through this, we hope to kind of make a difference in the legal world as not just lawyers who work on disability rights, but lawyers with disabilities who provide mainstream legal services. And this is also an opportunity for other corporates and service providers to broad base their diversity by partnering with law firm like Zen Access Law Associates. So with this, we launch Zen Access Law Associates. At the same time, it is my honor, privilege to thank Dr. D.Y. Chandrachud sir for his mentorship, his guidance, his commitment to disability rights, and his humbleness and his excellence and welcoming nature for just on one request of Rahul and mine to have come here, to have spent his evening with us, to have given us absolute valuable insights and kind of setting us for the future course of action that we need to take collectively in the sector and beyond. Extremely grateful, sir. Also grateful to Justice Pratibha Singh for coming here all the way from Delhi High Court and to be part of this event. We are extremely grateful, ma'am, for your support. Thank you to the lovely audience. I'm sure we had a lot to discuss, and as Rahul said, this is just first of such conversations. With Sir's mentorship and guidance, I'm sure we'll continue to have many more such conversations, and we look forward to having you with us in all such conversations. If you want to ever reach out to us, we are just a call away, or you could just send us an email. Our email is very simple, missionaccessibility@gmail.com. And Rahul and I are, of course, available, and with our amazing colleagues, Sara and Taha, Ayushmita. Thank you, everyone, for putting this event together, and thank you for being here.
Yes, may I also thank Radio Udan and Bar and Bench for being our media partners for this event. Chief Justice Chandrachud has agreed to take a picture with Team MA and then a group picture with the audience. So may I just invite my colleagues, Taha, Sarah, and Ayushmita to be here so that we may take a picture
And could we
with
also
him. Okay, yeah, sure. And Meenakshi as well. And well, then in that case, my family also.
That's it.
Yes, my mom is here, my brother-in-law and sister are here.
I met your mom for the first time, actually.
Yes.
Come. Okay, we have to sit, okay? Come, we have to sit, actually.
Yes.
I'll stand.
Okay. And yes, we forgot to mention Shruti is also here, who manages social media consultancy.
Hello, hi, I saw you in the audience. Oh, okay.
What is this? I cannot be after. You know, we designed just a second.
I know how much of thought and organization has gone behind this event today.
Yes. So she's Meenakshi, right?
Hello, Meenakshi. Good to meet you.
And sir, this is Ayushmita, my wife. I don't know if you
Hi.
met her.
So I've
My
seen
mom
your
you've
DP,
met.
and
You've already met my mom.
Yeah.
Yes, yes.
Thank you so much.
We also have Monica Bajaj in the audience for people who have insurance issues as persons with disabilities. You can reach out to her. Now let's take.
Ma'am, can you please raise your hand so that people know who you are?
Thank you.
Monica, ma'am.
Thank you so much. Lovely.
So we can take a group picture.
I request everyone, can you guys just be seated for a while, because we'll take one picture with him, and if everyone comes to the front, it will be a bit chaotic. So can you just be seated for a while, and then you can leave.